We're not doing a formality like thank you for being here. We're just gonna.
Welcome everyone, we are live on YouTube and I have the pleasure to meet now on a FIC my dear Cathy Rosalie Joly. You are a lawyer at Paris and Brussels Bar. With us we also have Laurent Ricard, forensic expert and vice president at Estelle. With us, Jude Dugan, you are associate electronic evidence officer at ICC. So, well, let's begin with the differences between e-discovery and forensic.
Yes, the idea is to define that what is e-discovery. The idea is that when a company A asks a company B to give information in a trial or in a mixed things, the company B has to fulfill the requirements and give the company A every kind of information they do have, either for or against them. It's not possible really in the Latin countries, because otherwise people will wipe out the information against them. So in Europe we do have, and especially in France, we do have a specific kind of operation, which is called in futurum order, where a lawyer asks a judge to give him a court order where a bailiff comes with an expert at the location of company B to do some kind of investigation and keep all the information related to specific keywords defined in the court order, and then this information will be kept by the bailiff. So this is the way we are dealing, though the company B is not informed that the company A will send a bailiff with an expert, instead of the e-forensics, where the company B is informed that they have to give the information. So that's one of the main differences, and every of them are different from forensic matters, which usually occurs in criminal case.
How could we define personal information, and what about legal privilege?
Personal data information is defined in the European directive as a very large scope. In fact, we have information relating to an identified individual, for example, a name, and also relating to an identifiable individual. And this specifically is very large because a person can be identified directly or indirectly. For example, it's the case regarding identification number, like social security number or credit card number. Also, when it's referred to one or more factor specific regarding, for example, physical aspect, DNA, for example, and also by combination of significant criteria, and you can understand that in this case it's very, very large. We have also, regarding personal data, sensitive data, and for example, it's information regarding race, religion, political affiliation, and in this case, it's not possible to collect this information in an easy way, because you have to comply with very limited and strict obligation. A legal privilege, it's different. It is a different approach if you are in common law regulation or in a Roman Germanic tradition, like in France, for example, because legal privilege in France is restricted to lawyer, because it's a professional secret for lawyer. That in other countries, legal privilege is also applicable to in-house lawyer. So it's the main difference between the two kinds of regulation. That means it's impossible to seize legal opinion issued by a lawyer, but also all meeting notes or a report of conference call. So it's very, very important to clearly identify in this kind of investigation what could be seized or not.
How do we deal with those kind of data in criminal investigations?
Well, it's exceedingly difficult. That's the short answer. I mean, to sort of echo that, the first issue, especially at an international level, is defining the privilege in the sense of what is culturally normative. So even now we have issues of sexual orientation, and what may need to be protected in one country is completely different elsewhere. But largely the primary focus in criminal in protection is witness protection. And that's your biggest obligation, to make sure you are providing all the identifiers for those people and going through a proper due diligent, holistic way of getting through all of your data as efficiently as possible and being able to market. So it's simple things like Facebook ID, Twitter IDs, phone numbers, addresses. It goes on and on about what may actually reveal what somebody is. It becomes incredibly complex. The other side of that is attorney-client doesn't necessarily happen as a big issue, but it goes through the same game of what is your sort of list of lawyers you may have to search for in terms of the communication. How do you run that through your indexes? And that's is just sort of repeating that process over and over again. I come from an e-discovery background, and the area that the shift that's occurring now in e-discovery is not so much about how do we efficiently review evidence, right? It used to be we went through a big stack of data, classified it as relevant and not relevant, and we spent millions of dollars doing this, and now we sort of figured out how to shrink that down efficiently. But now we have data protection as our dominant thing, and we have millions of entities all over the place, and from bring your own device, Internet of Things, all these factors are coming in, and they're in the same method that we use to classify millions of records of evidence is the same method that we would use for the classification of what is privileged and protected. And this is all part of the definition that seems to be happening, and the debate that seems to be happening is what is your due diligent obligation? And hopefully next month from Brussels we have some sort of indication about what that might look like, but that's all part of the same challenge that both criminal and commercial are facing together at the same time. Yeah.
Let's talk about Safe Harbor. Cathy Rosalie Joly.
Safe Harbor is an agreement between Europe and US regarding transfer of personal data. But the main point is that we have a decision on the 6th of October from the European Court of Justice that decided to invalidate the Safe Harbor agreement. So the situation is quite complicated regarding the transfer of data, of personal data to US. Of course, there are a time period that will decided by the G29 group. It's a group of personal data regulations that they decided, regulators, sorry, that they decided to let the possibility for company to validate, to continue the Safe Harbor put in place before the court decision. But this time period will end at the beginning of February, so we wait. All of us wait the decision, because of course if there are nothing new on the February, what will happen with this transfer of data? It's not possible to just block and stop the transfer. Of course, there is also other instruments that could be possible to use, for example, binding copyright rules or example clause defined by the European Commission, but of course it's a big issue to know what will happen.
Jude, you want to add something?
I would just say that it's a very exciting time. The standards that our industry will be known by are not yet defined. it's an interesting idea that while we have this same discussion going on in Brussels, we have in the criminal side, we have this umbrella agreement, which is being much discussed about. And they seem to echo each other in the sense that there's a creation of a data protection officer. There's an idea of that the data moves from the source onto the first hop, onto the second hop, and how you track that through. It'll be an interesting evolution. Yeah, absolutely.
Eric, Laurent Ricard.
I would like to conclude in a global way, just to say that whether or not you are bound by legal privilege or private data information, each company should evaluate the risk of the data they do have, the kind of data, and classify this kind of data. So they should do their own e-discovery process for themselves and to be able to evaluate the risk that they do have by treating this kind of information.
Thank you to the three of us, the three of you. I'm so sorry, yeah. Thank you to our viewers on YouTube. We are live. I give you a rendezvous in some minutes. Thank you.
Thank you.
Thank you.